Okay, so let's resume our discussion of Chapter 3. And let's clarify the rules with respect to quantity. Will failure to state the quantity of the subject matter affect the validity of the contract of sale? So in the case of National Grains Authority versus Intermediate Appellate Court, what happened here is that there's this farmer, Soriano, who offered to sell rice to the National Food Authority. So what NFA did was they gave Soriano a quota of 2,640 kavans of palay. Soriano thereafter delivered only 630 kavans of palay. Okay, but it later turned out that NFA did not want to pay Soriano anymore because they found out that he wasn't a farmer. And they told him to withdraw the kavans that he delivered to the NFA warehouse. So Soriano filed a collection suit against the NFA, and he was able to obtain judgment in his favor, and NFA was ordered to pay Soriano. So in order to avoid payment, NFA argued that the palay delivered to its warehouse did not mean that there was a contract of sale already between Soriano and NFA. So NFA invoked their procedure when they purchase rice from farmers. So they said that the whatever palay was delivered to NFA, it had to first be rebagged, classified, weighed, and then NFA would issue a warehouse stock receipt. So what happened between NFA and Soriano was that Soriano only offered for sale that 630 kavans of rice that he delivered to the NFA warehouse. So the issue in this case is whether or not there is already a perfected sale between Soriano and the NFA. So the ruling here is that there was indeed a perfected contract of sale between NFA and Soriano. So when Soriano offered to sell palay grains to the NFA, what NFA did was they gave him a quota of 2,640 kavans. And by virtue of that agreement between them, there was already a meeting of the minds between the parties. So there's already an object of the contract, which is the palay grains produced in Soriano's farm. And NFA was to pay for those palay in accordance with its quality, depending on the quality produced. So even if the exact number of kavans of palay to be delivered to the NFA was not yet determined at that time, it will not affect the perfection of the contract. Because under 1349 of the Civil Code, it provides that the fact that the quantity is not determinate shall not be an obstacle to the existence of the contract, provided it is possible to determine the same without need of a new contract between the parties. So NFA, when they gave a quota to Soriano of 2,640 kavans, only meant that Soriano can deliver such palay as he could produce, provided it does not exceed 2,640 kavans. So there's a perfected contract of sale here in this case of National Grains Authority versus IAC. On the other hand, in this Johannes Schubach and Sons case versus Court of Appeals, the court also found that there was a valid contract of sale between the parties. So in this case, it involved a purchase order. So there were several communications between the parties here. So the court took note that in one particular purchase order dated on December 24, 1981, wherein the buyer informed the seller that it wanted to avail of the prices of the parts and also attach a purchase order dated December 14, 1981. So to the Supreme Court, this meant that there was already an acceptance of the offer of the seller. So at this stage, there was already a meeting of the minds between the vendor and the vendee. So the object of the contract was the spare parts, and the consideration was the price stated in the offer dated December 17, 1981, which was thereafter accepted on December 24, 1981. So although the purchase order was silent on the quantity that was to be ordered, however, the buyer here later communicated the exact number of quantity that he wanted to purchase. And this was done on December 29, 1981. Okay, so to summarize the rules on quantity, so in National Grains Authority, we learned that there was a determinable subject matter when the maximum quantity was agreed upon by the parties at the time of perfection. While in the Johannes Schubach case, the subject matter was also determinable because the buyer issued a purchase order even without specifying quantity. But that purchase order was already accepted and the price was also indicated by the communications between the parties. And the quantity was actually fixed right after the acceptance of this purchase order. So the rule is that even when the exact quantity of the subject matter of the contract of sale has not been agreed upon, but the fact that the parties have come into an agreement as to the quality, the price, and the subject matter of the sale, then there's already a perfected contract of sale. Okay, and in addition, this kinds of agreement wherein quantity is fixed after perfection of the contract, it's in the nature of a supply agreement. So to Villanueva, this is actually a preparatory contract to a contract of sale. So let's not forget, okay, that the thing, when it is generic, then it should be made determinate. And this should be done at the time of perfection of the sale. So as long as it is capable of being made determinate without necessity of entering into a new agreement, then that will suffice to produce the perfection of the contract. However, it's a different case when it's already time for delivery of the subject matter. So although for purposes of perfecting the contract of sale, it's enough that the generic thing is capable of being made determinate. But at the time of delivery, that generic thing must already be physically segregated or particularly designated of all others of the same class. Because this is the time when the obligation to transfer ownership will arise. So at this moment in time, at the stage of the contract, when it's time for delivery, that subject matter well, it is capable of being made determinate or was determinable at the time of perfection, it must already be determinate at the time of delivery. So, pinaka-latest time na mo-comply siya to the requirement of being a determinate subject matter will be upon delivery. So what's the consequence when the thing, subject matter of the sale, is not determinate or is not determinable? Then it is void pursuant to Article 1409, subparagraph 6, wherein a contract is considered as inexistent and void from the beginning, where the intention of the parties relative to the principal object of the contract cannot be ascertained. Right? Different ang ground niya. When the thing is not possible or could not come into existence, it's void under 1409 subparagraph 3. But if it's not determinate or cannot be made determinable, then a different ground. Kani siya, 1409 subparagraph 6. So to summarize, guys, these are the consequences when not all the requisites of valid subject matter are present. Diba? It should be a possible thing, it should be licit, it should be determinate. If that's not the case, then general rule it's a void and inexistent contract. And void contracts, as we know, do not produce any legal effects. But there are cases when even if void, it will produce effects, such as when what is involved is an illegal contract. Illegal meaning it is the subject matter is illicit. And there's also an instance when contract is not illegal per se, but it is merely prohibited because of public policy. So that's another situation when a void contract can produce legal effects. And of course, there's the no contract situation, wherein if the subject matter cannot come into existence, then the subject matter is not a possible thing, then no contract at all could have arisen between the parties. So just to recap or remind you of what are the effects of void contracts in general, remember that it will not produce any effect. Okay, and the parties will have no remedy as against each other. The contract cannot be ratified, and the defense of illegality or inexistence or absolute nullity cannot be waived by any of the parties. And it's not also available to third persons who are not affected by the contract. So the action or defense against a void contract will not prescribe, and it can be assailed by anyone at any time. So in relation to the contract of sale, these are some of the reasons that will make the contract void. Okay, when the cause, object, or purpose is contrary to law, when there is no cause or object, when the object is outside the commerce of man, when it contemplates an impossible service, or where the intention of the parties relative to the object cannot be ascertained, or when a contract is expressly prohibited or declared void by law. So this all deals with the cause or object of the contract. And if any of these are present, then the contract of sale is void. Okay, but there are certain exceptions to the effects of void contract that we must consider. So in illegal contracts, it can produce legal effect when the parties are not of equal guilt. So we'll know more about it once we study Article 1411 and 1412. And in a no contract situation wherein it is made void because the thing could not come into existence, then what will happen is that the innocent parties to this case can still recover whatever was paid. And the legal basis for recovery of the price is the principle of unjust enrichment. A third situation will be that found in Article 1416, wherein a contract is not illegal per se, but it is just prohibited by public policy. And the consequence is that there can be recovery of whatever was paid or delivered, provided that it will enhance public policy. So do you remember this, guys, in your law on obligations and contracts? So in these four scenarios, there is an illicit cause or object, okay? And in one scenario, the cause or object of the contract is illicit, and entering into that contract actually constitutes a criminal offense. So there's a different rule if it will not constitute a criminal offense. So when it constitutes a criminal offense and both parties are at fault, then we apply the in pare delicto rule, wherein the parties shall have no action as against each other, and they can both be prosecuted for violation of the law. In the event that only one party is at fault, then the innocent party can claim what he has given and shall not be bound to comply with his obligations or his promises. But if the contract does not constitute a criminal offense and both parties are at fault, then the in pare delicto rule will still apply. And if only one party is at fault, then the party at fault cannot recover what he has given or ask for the fulfillment of what has been promised him. But the innocent party, of course, can demand the return or reimbursement and is not expected to comply with his promises. So this in pare delicto rule, guys, there are exceptions. Exception na siya daan, napagid siya exceptions. So we don't apply the in pare delicto rule in the event that one of the parties or both parties will repudiate the contract before its purpose has been accomplished or before it causes any damage. And we also do not apply the in pare delicto rule when one of the parties is incapable of giving consent. Of course, ma-relieve si innocent si incapacitated party ani kay incapacitated jud siya. Then Article 1417 is also an exception to the in pare delicto rule because there can be recovery of the price paid in excess of the maximum price fixed by law. So naay suggested retail price na muna siya pinaka-maximum. If you exceed that, you're violating the law. But the buyers here really want to purchase the property and are willing to part with their money. So the buyer here is also breaking the law. So even if the buyer is breaking the law, the buyer can still recover the price paid in excess of the maximum price set by law. Okay, but the in pare delicto rule, well, there are exceptions to it. There are also instances when it is not applicable at all. So in breach of warranty cases and in contracts which we consider as simulated, meaning simulated ang price. So in a simulated contract, this is a void contract. It is considered to have never existed. So we don't apply this in a simulated contract because the in pare delicto rule will only apply if the contract is existing already, right? So in some bar years, they have asked questions about contracts na entered into in violation of law. Ano siya, when you sell private agricultural land to foreigners, so that's a violation of the constitutional prohibition. So there's an illegal contract here. But in accordance with case law, if it is subsequently transferred to a Filipino, the land which was sold to the foreigner, then it will cure the illegality of that first contract. So the property can no longer be recovered if it is already held by a qualified Filipino. So same rasa din siya sa katong previous bar question. There's no more right to recover the property. So remember that Article 1459 has two clauses. So we will discuss the second clause of that article, wherein it is required that the vendor must have a right to transfer the ownership of the subject matter already at the time of delivery. Okay, so this is an important article, guys, because this tells us when the seller should already acquire ownership or the right to transfer it. So question, can you sell what you do not own? So my Saturday class, ang ilang na yung mga ni answer aning yes, you can sell what you do not own. Because in a contract of sale, the thing, subject matter of the sale can be one that is yet to be acquired by the seller. So that's partially correct, but actually the general rule is that no, you cannot sell what you do not own, because the rule is always nemo dat quod non habet. You cannot sell what you do not own. However, in the law on sales, the seller need not be the owner at the time of the perfection of the contract. But the seller must already have the right to transfer ownership at the time of delivery or at the consummation stage. So the acquisition of the subject matter by the seller may be made to depend upon a contingency and would not actually affect the validity of the sale since it was already perfected, di ba? So what happens if the seller has no right to transfer ownership at the time of delivery? Then that's the rule. That's the time when we apply the rule of nemo dat quod non habet. Okay, and we apply Article 1505. So therefore, the nemo dat quod non habet, which is the general rule in Article 1505, applies at the consummation stage, or the time when the seller is supposed to deliver the property, the subject matter, the time when the seller must already transfer ownership to the subject matter. So what is 1505 all about? In this article, guys, general rule is that where goods are sold by a person who is not the owner thereof and who does not sell them under authority or with consent of the owner, then the buyer acquires no better title to the goods than the seller had. So the buyer here will only step into the shoes of the seller. And if the seller, as it would turn out, has no right or interest in the subject matter, then no right or interest or title is transmitted to the buyer. The only exception to this is when the owner of the thing that was sold by another without his consent will perform acts that will constitute as estupel, wherein the owner of the thing cannot anymore deny the authority to sell of the seller. So there is as if ratification on the part of the owner of the thing. So in that case, then the buyer can acquire better rights to the to the subject matter, even though the seller had no right in the first place. So what's the liabilities of the seller? What are the liabilities when the seller cannot transfer ownership at the time of delivery? Of course, liable for breach of warranty against eviction. Okay, if that's applicable. Then the buyer acquires no better title to the goods than the seller had. So what happens to the contract if there is a failure to perform an obligation? So seller must transfer ownership at the time of delivery. If he violates this obligation, if he cannot do this, will the contract of sale become void? So that's the question that is answered in the case of Null versus Court of Appeals. So in Null versus Court of Appeals, guys, there is Conchita who mortgaged lots to the DBP to secure her loan with the bank. And when she was unable to pay the loan, DBP foreclosed on the lots. And Conchita was not able to redeem the lots within the given redemption period. So that's the first phase of the story. The second phase here involves Conchita selling the lots to her brother, Anacleto, for 100,000 pesos. So under their agreement, what Anacleto, the buyer, is supposed to do is he is going to pay 56,000 to DBP. Then Anacleto will give 30,000 to Conchita as down payment. And there is a remaining balance of 14,000. So, maro sa din si Conchita, no? Utangan pang yung brother niya, no? So, Anacleto agreed and they executed a deed of sale. And Anacleto also gave her sister Conchita the right to repurchase the lots. So Anacleto was able to negotiate with the bank, DBP, and he was able to cause the transfer of registration of the title in his name. So while all this was happening, guys, Conchita remained in possession of the lots. And the remaining 14,000 pesos was still not paid by Anacleto. So much later, Conchita was ready to repurchase the property from her brother. Okay, but Anacleto here already refused. And he demanded the return of his 30,000. And he demanded turnover of possession of the lots. So why did Anacleto do that to his sister? Anacleto contended that at the time that Conchita sold the lots to him, she was no longer the owner, right? And his position was that he actually ended up purchasing the lot directly from Development Bank of the Philippines. Kaya di ba siya man negotiate with DBP? So he wants Conchita to return the 30,000 and as well as surrender possession of the lots to him. So what Conchita did was she sued her brother to exercise the right to repurchase. So does Conchita have the right to repurchase? So the court here held that there is no longer any right to repurchase. The court here said that Article 1459 requires that the vendor must have a right to transfer the ownership thereof at the time of delivery. And when the delivery has become impossible already because it was already owned by another, then it involves a situation wherein the cause or object of the contract contemplates an impossible service and which makes it void under Article 1409, subparagraph 5 of the Civil Code. Here, the delivery of the property by Conchita to Anacleto became impossible because DBP was already the owner of the lots when Conchita sold it to her brother Anacleto. So the sale to Anacleto was void, and therefore the ancillary contract of repurchase is also deemed inoperative and also void. So, do you agree with this ruling of the court? So far, sa inyong na-learn sa ato ang discussion, is this the proper way to treat the contract between Conchita and Anacleto? Right, so there is criticism with respect to this Knoll versus Court of Appeals ruling. And that criticism is coming from our favorite author, Cesar Villanueva. So he says here that he does not agree with the ruling because it should not be void under Article 14095. Kay the obligations of the seller in a contract of sale is actually a real obligation. So it is not a personal obligation. And the proper remedy of the parties, the proper remedy would not have been to void the contract, because there was, at the time of perfection, all the requisites of the contract of sale was present. So there was only a problem at the time of the consummation of the sale. So the remedy would have been to just rescind the contract of sale, and the same effect would be reached. The same conclusion would be reached, that there would be no right to repurchase on the part of Conchita. Okay, let's contrast the Knoll ruling with this case of Quijada versus Court of Appeals. So in Quijada versus Court of Appeals, guys, what happened here is that Trinidad and her siblings donated a parcel of land to the municipality of Talacogon. Okay, but this donation was subject to the condition that the land would be exclusively used as a campus of the provincial high school. So if this condition is not fulfilled, then there is an automatic reversion in the deed of donation, wherein the properties will be reverted back to the donor. So despite the execution of the deed of donation back in 1956, Trinidad remained in possession of the land. Kaya wala gyud siya gidevelop sa munisipyo. So in 1962, Trinidad sold a portion of the land to Regalado in a deed of sale. And thereafter, the remaining portion was sold again to Regalado in an oral contract of sale. In 1987, the Sanggunian of Talacogon passed a resolution reverting the donated land back to the donors. So, nag-give up na si munisipyo na makatukod siya og provincial school in that donated land. So, what the heirs of Trinidad did, because at that time, they wanted to recover the property from Regalado, they argued that at the time of sale to Regalado, Trinidad was no longer the owner of the land because she already donated it to the municipality. And therefore, Regalado did not become the owner of the land, since the ownership only reverted to Trinidad and her heirs in 1987. And the sale to Regalado happened before the reversion of the municipality. So what do you think, guys? Is this contract void? Because at the time of sale by Trinidad, she was no longer the owner. So the ruling here is that no, the sale to Regalado was actually valid. So why is the sale valid? So there must be a distinction between perfection and consummation stage in a contract of sale. So at the perfection stage, ownership by the seller of the subject matter is not really required. What the law requires is that the seller will have the right to transfer ownership at the time that the thing sold is delivered. On the consummation stage, what happens is that upon the constructive or actual delivery of the subject matter to the buyer, when the seller or her successors in interest subsequently acquires ownership thereof. So this consummation stage, guys, uh, the right to transfer ownership can take years on the part of the seller. And as long as the contract of sale has not been rescinded or annulled or nullified, then this obligation will actually persist. So what happened here is that by virtue of Article 1434, which provides that title passes by operation of law to the buyer the moment that the seller will acquire ownership or right to transfer ownership over the subject matter. So that meant that even though Trinidad donated the property to the municipality and she sold it to Regulado, and it was after the sale that the ownership reverted to Trinidad, considering that there was delivery of the property already to Regalado. So he took possession of it, correct? So the moment that Trinidad reacquired ownership over the lot, then her obligation to transfer title to Regalado subsisted. And by operation of law, it passed on to the buyer. So this rule, actually, in 1434, it applies not only when the subject matter of the contract of sale of goods. It also applies to all other kinds of property, including real property. So therefore, the heirs of Trinidad are bound by the sale executed by Trinidad. Right? So there's an exception to the rulings, to the ruling in Quijada, wherein there cannot be automatic passing of title by operation of law to the buyer. And this is what happened in the Cavite Development Bank versus Spouses Lim case. So in this case, Rodolfo mortgaged property to secure his loan with Cavite Development Bank. So Rodolfo was not able to pay off the loan, and the bank foreclosed on the property and later became the owner after Rodolfo failed to redeem the property. So Lolita offered to purchase the property from the bank, and the bank accepted the offer, and Lolita was able to pay option money